So I have a segue for you because I know you want to talk about attorney well-being. And my segue is, have you been spit on by a potential client yet?
No. I actually do a lot of my intakes. I do a lot of my intakes over the phone or via Zoom these days. I do some in-person intakes too, but I have not been spit on. But I think part of the why attorneys in general and are so unhappy, litigators, I should say, is that it's a conflict based job.
Mhm.
Um, so I think you need to have a certain temperament. You need to just be okay with it, and you need to sort of just you need to look at it with some objectivity, right? You can't let the conflict that you're having with opposing counsel or with even potentially with a client, you can't like get let that get to the core of your being.
Yeah.
But I think maybe a potentially even bigger driver of attorney unhappiness is just some of what the job requires or doesn't require physically.
Oh,
Like there's so much time like spent staring at screens, which is inevitable. You need to do it for part of the job. You need to read the documents. You can't print out the 300 pages or 1,000 pages of discovery materials. Um, but I think not moving, and I think not look staring at screens for so long is not so good for people. Like I think we're gonna like this is not a problem just for attorneys, it's a problem for white collar folks in general.
mhm.
Um, and I think maybe in a few hundred years we're gonna look back and be like, that was nuts. Like that's how we ran our lives. We were like constantly staring at these devices. And then we went home and we relaxed by staring at devices. And so, what I'd like to do, I'd like to implement things like standing desks and put a little treadmill under the standing desk, and spring for some legal dictation software so you can just look away more often.
Yeah, that's smart. I mean, I don't know if you can see it. I have a row machine right
Yeah,
there. And I agree completely. There's definitely phone calls that I have where I'm just like, all right, next call has got to go to someone else. I'm taking half an hour. Like I can hear myself and I can feel I have a temper problem. Um, and so I can hear myself getting that way.
hmm
And I know two things. One, not my best self, not being respectful. Two, my decision making goes down significantly when I get that way, right? And to your point, that's important when settling cases, important when figuring out tactically what you're going to do, but it's also important when taking cases
yeah,
more than anything, right? I track my caffeine intake because I want to make sure decision making is everything, right? In our field, it's creativity and decision making, to my mind, right? So I couldn't agree more. Do you have a support structure? Because you're solo right now. You're working with other firms, but are you coming together with other attorneys in your field to have that experience?
yeah. So Chicago's got a great community of plaintiffs attorneys. I have attorneys that I just talk through cases with. Like, does this number make sense for the demand letter? What do you do in this situation for this particular discovery issue? Should I file this case with the EEOC or with the Illinois Human Rights under the Illinois Human Rights Act? I mean,
Sure.
that's so yeah. I do think that I do think that's important. Otherwise, if you don't talk to other plaintiffs' attorneys, you're going to just get gaslit by the defense bar.
No, I can remember I said something stupid and I'm like, yeah, listen, I don't know if it was stupid. I said something aggressive in a mediation. And obviously mediations are supposed to be confidential, but defense counsel was trying to take me to the judge for what I said. The guy had said something like, how can you do this to me? I've got kids. I said, don't worry, man. You can keep them. We're not here for them. Or something to that effect. And like defense counsel was like trying to get me sanctioned or something with the judge, like trying to make an issue out of it. I remember going to an older, wiser attorney in our field and being like, oh my God, I'm facing he's going to make a motion for sanctions. And the guy was like, okay, yeah. So he does that every week. That's what he does. That's his move. That's his like thing. And it's working on you. And just that was like, oh, yeah, I guess it is. That he just always does this. And that was the guy's
But
move.
I mean, you know what? That story bothers me so much because can you imagine a plaintiff's attorney doing that? Can
Oh,
you
can
imagine a plaintiff's
we
attorney
don't get equal standing.
going
We
to a
don't.
judge and saying like, I want sanctions for something management counsel said in mediation to my client? I mean,
Yeah. Yeah. I guess there's no question in my mind that unless it's tied to discovery, we do not have equal standing in terms of the presumption of ethical correctness with defense counsel, because they are those white shoe firms. They're judges look at them and say, I'm gonna probably retired at one of your firms, or I probably came from one of your firms, right? It's not, and we're just these shysters almost in some judges' eyes, right? I shouldn't use that term. That is a racially charged term. We're these awful ambulance chasers, I guess,
sure.
To avoid anti-Semitism. My goodness. And yeah, I don't think there's ever going to be inequalities between both sides of the aisle on that. Because we tend not to become judges. I mean, I don't even know what my path to judgeship would look like, and I work as an arbitrator. But
Yeah. Yeah, I mean, though I gotta say, Chicago, the Northern District of Illinois, is like surprisingly good at that. Like
oh,
I've
is it?
seen, it's not all people from Kirkland and Ellis. Like there's some
Okay.
extremely there's there's some very good employment law plaintiff side firms, and there's some very good plaintiffs firms in general. And
Okay.
those people do have a path into respectability.
I love
Um,
that. I love hearing that. In New York, it's very much kind of a one-party system, and you have
oh, okay,
to make the correct donation to be put on for election to become a judge, a state court judge. So within New York City, you know exactly which political party you're making your donation to, you know roughly how much, and then you'll generally be run unopposed.
sure.
So
Oh,
it's
I was talking about federal judges. I don't I actually
oh
don't.
yeah.
Um,
Well, the federal judges are a different breed in a lot of ways.
yeah.
I have to say, federal judges have done amazing things for me um, over the years.
Mhm.
I have no complaints about the federal judge course, certainly. Okay, so what else have we got? We got about 15 minutes left. What should we touch on? Doesn't have to be anything. I just want to make sure we're
Well,
getting.
let's I'll how about this? Let me tell you maybe one thing that I took away from your channel that's actually been remarkably effective for me and
Oh,
has sort of gone against my instincts.
I feel like you can do better than me, in all honesty. Like,
Um,
but I
no,
hope
well,
you're doing so in some way.
it's helped me. So, you know, I wanted to send these very, and I've heard two perspectives on this, but I will say that I've had some traction with your approach. Um, my instinct was always to write these long, detailed demand letters, right? Like, let's get the client text messages. Let's put the text message in there where she reported the harassment, and the text message where you told her she was an amazing employee and she wouldn't quit, and that you would address the harassment, and then the text message where she said you're not addressing the harassment, and then the text message where you fired. Um, and unbelievably, like I would sink all this work into a letter and get ghosted. And one day I heard on your channel, like, don't write long demand letters. Just leave it to their imagination. Um, So and I got to tell you, it's come to a pattern at this point. Here's the most egregious thing that happened to my client. Let me hear from you in 10 business days, or I'm coming for you.
That's almost
Um,
exactly what we do. I love that. I think the human mind fears the unknown inherently. I think that's
yeah,
something inherent in us. It's worked great for us. And we used to do it. We followed the same progression. We used to have these big, built out letters, and the response rate was unimpressive, to say the least. And then we went to this path, and the the deadline seems to really get people.
it
It
could just be
seems
it could just be the deadline.
it
Like,
could be.
but I think sending a really long, detailed demand letter, and I don't want to knock you because there's attorneys who I really, really respect and I think are doing amazing work who've
Mhm.
told me I'm wrong about this, but I'm just telling you what's worked for me.
Yeah.
Um, Very short demand letter. I'm coming for you in 10 days. And I think if you send the long demand letter, I could, in certain circumstances, send the wrong message. And the message you're sending when you send a really long demand letter is, I want to settle this pre-litigation. Look at all this work I did. Pay me now. I don't feel like litigating this. But if you write a short letter and say, yeah, we can talk about settling this thing, but if you don't we're going to kick off in 10 days. They're like, oh, this person, if it's a Section 1981 claim, they might actually file the darn thing. If it's a sex harassment case, they're going to file a charge. This thing is going to get up and running, and they're willing to file and, if need be, try the case. And I think that's sort of like what's in between the lines of a short demand letter. And I do think, and I know it is exactly how you do it because I stole it from you. I stole the move from you. But I have to say, like, it's been amazing. It's like I went from getting ignored to like, and you know what? I did put some scary jury verdicts in there. So I don't put a number in there. But I'm like, hey, look at this Section 1981 case where the jury awarded $135 million in punitive damages, and the HR lady who reads the letter doesn't know that maybe that they're not going to collect all of that, but it does. It's been nice. It's been nice to like, oh, like I got in touch with opposing counsel in 2 days.
Yeah. And that builds confidence in your client as well, which is incredible.
Yeah.
I think we might be sleeping on one component. The firms that I knew, or I guess still know, who did letter practice purely do very involved, extensive letters. It might be that we look,
Oh,
if you do a longer letter, you look like one of those firms. Could be. I don't know.
so I mean, how does that even work necessarily? I can't imagine running a firm where you don't file any cases, but apparently it's a thing. So I
Oh,
don't.
it's very common. So it's all about overhead. And there's different ways to do it. Like I know a guy who does a letter practice and then will work up a case as a package and like shop it to firms to get it brought forward. Like, and I don't,
Oh well, that's a legitimate. That's a
it's very
legitimate.
legitimate. Yeah.
Yeah.
But I also know firms that will, excuse me, write 5 letters and expect payment on one. But their overhead is so low that somebody who just doesn't hire an attorney or a case that like has hidden facts that maybe she or he doesn't even know as the plaintiff's attorney, like
Mhm.
I've seen cases that settled and the underlying facts, I'm like, how would this go for so little? And then you realize the underlying facts that I'm looking at are not in the letter. The attorney didn't know, didn't spend the
Mm.
time, just got an easy 20, 30, 40K, and got out. And spent so little time that it was a great deal for that attorney, but horrible for the client. And now the client signed a general release and is like, well, what about these events that weren't in that letter? But you signed a general release. It's
Sure.
gone. I see that happen a lot too. So there's a spectrum, but a lot of them are just doing lots of letters, and a lot of them will do public accommodation and housing accommodation cases as well. So
Okay.
they're like, oh, you didn't accommodate this person in the gym because you don't have an elevator. Well, that gym's just going to cut a check 100% of the time, right? Probably for 10 grand. So they exist on that stream of money, and then they do it for housing and they do it for employment. And They don't really pay attorneys. They just have a couple of paras doing intake and letter writing, and the attorney reads and signs. And the margins are amazing. And maybe you're even helping some people, but it makes me very uncomfortable.
Employment law is comparatively a lot more work, and there's a smaller pay.
And that's what I always say when med mal attorneys, NPI attorneys come into our field. I always, part of me watches it happen, and I just think, you're not going to like it. Like, our margins are tighter, our cases are smaller, and we're working 3, 4, 5x for the money. Like, it's complex litigation to get it done right. If you're not flipping cases, it's really a lot. And I watched a big national PI firm come into our field 3 years ago, and they even took the stance like, you should just give us your cases. We'll litigate them for you. We'll make you more money. I was like, how many employment attorneys do you have? Like, how many do you have on the books right now? I know one that you've hired. I know one, and he's amazing, but how are you staffing this? And they're like, oh no, we have, I don't want to say how many attorneys because it'll ID the firm, but like, we have hundreds of attorneys. And I'm like, sure, you do. You're a good pedigree firm. How many of them do this? No answer. And it's fascinating, this idea that like, it's easy money. You guys are just saying people did bad things and it's easy money. It's like, no, it is hard money. It is very hard money in many ways. I don't get it. Yeah.
No, yeah. Um, fundamentally, when you make some of the accusations you have to make to represent these people don't want to believe it about themselves.
Yeah.
Like even if it is true, like they don't want to admit it, or they don't want to admit it to themselves.
It's possible in this field for your defendant, your bad actor who did horrible things, to fully and sincerely believe he or she is innocent. Really, I think it is. I have gone after people who are like, I'm not racist, and they'll say things like, I have black friends, and you're like, that's a you're engaging in it right now. Like, you're doing it right now. And they're like, no, I hired your client. I would never. And I'm like, but you don't pay people of a certain race the same, and they don't get promoted. And you make weird comments. Like, you're not a good person in this way.
Yeah. Well, I've seen, without getting into specifics, I've seen people sexually harass women in emails in which they deny sexually harassing women.
Yes.
It's extraordinary. Yeah. It's like,
it's insane. I always, the cases where they're like very clearly flirting in an email about a raise or a promotion, and it's like, my guy, you could not make it any more clear. Like, you are very much trying to leverage this money or this promote, whatever it is, for some kind of like back and forth gratification. And that guy would come back and be like, I didn't ask you to sleep with me. No, but you made some very suggestive comments that she had kind of to respond to because she's got a family to feed.
Yeah.
Yeah. But that guy would, in the same way, be like, I didn't do it. I'm innocent. You're just looking for money. It's like, I mean, come on. I don't know. How did we do? Did we do okay?
I think we're good. We've been going for a while now.
Yeah, we got about 3 minutes left. Anything else you want to cover? Like, we need your link tree. We need all your links for everywhere you want us to send people.
Sure.
Sure. I've been saying for a long time that people in Illinois should not be hiring my firm because there are really good options, especially in the Chicago area, for employment attorneys. Is it, can we kind of send folks your way for a consultation?
Yeah.
Do you offer a free consult?
Yeah, absolutely. I will provide all those links. I took with you that I do not charge for consults, and you'd be nuts to charge for consults. But I guess, you know what, I'll send you all the links and all the stuff. But I will say this: I just want to take the last minute or two to just express some gratitude because I know the channel is for pro se plaintiffs, but I've already given you a few concrete examples of how like it's made my life concretely better to like pull things from your playbook. So thanks for putting that information out there. I'm gonna keep listening.
I really appreciate you saying that. I can't tell you how stupid it feels to make this. Like, I know you create some video content too. I feel like a weirdo creep insane person when I talk into this camera. Like it feels bad a lot of it's very unpleasant.
No,
So it really makes me happy when folks say that it's helping in some way. I'm so excited for your practice. I hope that you come back on the channel sometime. I would love to do this like quarterly to check in on your practice. I would love to have you come on and talk about the process of getting intake set up because people don't understand that process at all. Make me very happy if we could keep doing this and get that going.
I would love that too.
Awesome, man. It was really nice to talk.